morning. Thank you very much for joining us, or welcome back. This is European Law Interviews, a program sponsored by the Jean Monnet Chair, which is part of the European Commission Training and Education Program. We have the great opportunity today to interview Professor Nicolas de Sadeleer. Good morning, Professor.
Hello.
He's a professor in EU law at Université Saint-Louis Brussels and Université Catholique de Louvain. Today we will talk about Article 114 TFEU. In previous interviews, we discussed the issue of harmonization, positive and negative harmonization, and we saw how this concept of harmonization can help get rid of diverging national policies in order to achieve the harmonized market and in order to create a common playing field. There are different ways to achieve harmonization on the environmental area. We can use Article 192, which is the genuine environmental basis. It is a very specific provision because it allows member states to enact more stringent measures. However, there is another provision. It is Article 114. It is the article that we are going to deal with today. This article is also quite specific because it doesn't allow member states to adopt more stringent measures. In order to be very clear today, I'm going to read paragraph 4 and paragraph 5 of this provision. So paragraph 4 reads as follows. If after the adoption by the European institutions of a harmonization measure, a member state deems it necessary to maintain national provisions on grounds of major needs referred to in Article 36 or relating to the protection of the environment or the working environment, it shall notify the Commission of these provisions as well as the grounds for maintaining them. Paragraph 5. Moreover, without prejudice to paragraph 4, if, after the adoption by the European Parliament, the European institutions, of a harmonization measure, a member state deems it necessary to introduce international provisions based on new scientific evidence relating to the protection of the environment or the working environment on grounds of a problem specific to that member state arising after the adoption of the harmonization measure, it shall notify the Commission of the envisaged provisions as well as the grounds for introducing them. The first part of today's interview will be devoted to justification of the requests for derogation. So paragraph 4 of Article 114 is dealing with the maintenance of domestic measures adopted before the harmonization. Paragraph 5 is dealing with measures adopted after harmonization. So it is very different. My first question would be, Professor, don't you think that the grounds for justification of new domestic measures are too limited?
Grounds for justification are extremely limited regarding the adoption of new measures, whereas former measures predating harmonization can be justified in the light of the grounds of justification listed under Article 36 or on the grounds of environmental or workers' protection. The adoption of new measures after the harmonization has been entered into force can be justified exclusively on the ground that the state is pursuing environmental protection or workers' safety.
So it is easier for states to maintain and preserve former measures?
Indeed. The rationale is that former measures predate harmonization, whereas with respect to new measures, the EU institutions could not have been taking these into consideration while drafting the harmonization measures. In so doing, the member states are likely to undermine to a greater extent the functioning of the internal market.
Okay, thank you, Professor. In reading the provision, it struck me that consumers and health protection are excluded. Why is it so? Those areas are quite intertwined.
Yes, consumer protection is not relevant regarding the adoption of new measures. They cannot be encompassed within the scope of ambit of either environmental protections or workers' protection. For instance, Cyprus lodged an application to adopt new GM measures relating to supermarkets in order to oblige the supermarket to place GM products in particular places within the food sold. That proposal for measure was justified on the grounds of consumer protection, with a view to allowing the consumer to differentiate between non-GMs and GM products. The European Commission discarded that application on the ground that it was justified, not regarding environmental protection but on consumer protection, a ground for justification that's not listed under paragraph 5. Regarding health protection, all the commentators of Article 114 have been struck by the fact that health issues are dismissed. So why on earth health issues were dismissed? There is no answer to that. However, it's extremely difficult to draw a dividing line between what belongs to environmental protection and what belongs to health protection. In particular, that one of the aims by virtue of Article 191 of the Treaty on the Functioning of the European Union of the environmental protection is to enhance health protection.
Okay, thank you, Professor. And then are those national requests to adopt more stringent measures subject to further restrictions?
Yes, in addition to this, paragraph 5 of Article 114 obliged the member states to demonstrate that the risk it is facing is specific to that member state. It's not a general risk faced by the community in its own right. That the problems entailed by the risk occur after harmonization occurred. And thirdly, that the member state is able to back up the allegation of the existence of the risk by scientific evidence.
Okay, and so are these conditions cumulative?
Yes, indeed. The Commission has to verify whether these three conditions are fulfilled in order to grant the authorization to the member states applying for the adoption of new measures.
Okay, thank you. If you don't mind, we will now focus on all conditions, starting with the first one, so the specificity. Has it to be unique?
No, not at all. The idea of specificity is to avoid that member states requesting the adoption of new measures regulate areas of a general character. The treaty framers were conscious that the member states, under these circumstances, had to demonstrate that specific ecological, geographical, epidemiological circumstances were rendering the risk specific to the applicant member states. So in particular, population density, the level of historic contamination, the degree of industrialization, the vulnerability of the ecosystems or the part of the population like the children are likely to exacerbate the extent of the risk in a particular member state in contrast to the other member states of the European Union.
Okay, and do you mind offering us some illustration?
Yes, indeed. Firstly, the Commission had to deal 15 years ago with a request from Netherlands to ban creosote treated wood used in water. Given the extent of the aquatic environment in Netherlands, the Commission took the view that the use of the treated wood that substance in treated wood in Netherlands was much more significant and was leading to much more significant environmental impairment in that specific country than in the other countries. By contrast, in the organostatic paints case that was lodged by both Belgium and Germany, the applicants claimed that the use of antifoulant paints in harbors or ports was leading to a greater ecological impairment regarding the mudflats than in other countries. The Commission dismissed that argument on the grounds that the endocrine disruptor effect of antifoulant paints was encountered all over the world in every harbor. So the Commission concluded that there was no specificity regarding to this endocrine disruptor effect. A third case in point will be the GMO lands Oberösterreich case. The province of Oberösterreich claimed that cultivation of GM seed in that particular province was likely to threaten unique and specific ecosystem. Both the court, the General Court, as well as the European Commission dismissed that argument. They didn't see any specificity regarding the agricultural ecosystems of that province. A fourth case in point will be the Dutch particle matter case. You are aware that given the density of its population and the level of industrialization, Netherlands is subject to a very high concentration of particulate matters. And in 2004-2005, all the air quality thresholds in the Netherlands regarding particulate matters were exceeded. For that specific reason, the Dutch authorities requested, under paragraph 5 of Article 114, the authorization to apply more stringent standards regarding diesel-powered vehicles, in claiming that the Netherlands were facing more significant air pollution difficulties than other countries like Czechia or Belgium. The European Commission dismissed that argument in stressing that the situation was equivalent to the Belgian situation or was not worse than the Czech situation. That argument was upheld by the General Court, but however it was dismissed by the Court of Justice. The Court of Justice applied the Technische Universiteit Munkent case law, claiming that the European Commission was called on to examine carefully and impartially all the relevant elements of the individual case, and in particular, in order to fulfill adequately that obligation, the Commission was called on to explain in its decision the reason for which it decided, in spite of all the Dutch report, that there was no specific problems in the Netherlands. So, in a nutshell, specificity is not tantamount to uniqueness.
We will now move to the second condition. The provision states that the environmental problem has to occur after harmonization. What about problems occurring before harmonization?
Well, as a matter of principle, paragraph 5 requires that the problem occurs after harmonization took place. However, one is aware that environmental problems are notorious for revealing themselves gradually. Scientific knowledge proceeds incrementally, as you are aware. So any strict interpretation of that conditions is likely to render such a condition or the whole procedure nugatory. Environmental risks are present at the moment often that the harmonization occurs, but these environmental risks are likely to appear much more significantly 5 years, 10 years, 15 years later. So of importance is to interpret that conditions with a maximum of flexibility.
Okay, thank you. We will now move to the third condition, if you don't mind. So, scientific proof. What is the amount and quality of new scientific evidence required?
Of importance is to oppose scientific evidence to scientific proof. Scientific evidence, by contrast, does not require that the state applying for the derogation shed completely the light on the link of causation between the product or the substance and the likely damage. Scientific evidence entails a possible link of causation between the product at issue and the occurrence of the damage. As a result, the member states are not called on to furnish irrefutable proof with respect to the risk. That means that state authorities can reckon upon decent scientific opinion, can reckon upon the analysis carried out by their own epidemiological or ecological institutes.
Okay, thank you very much. We will now move to the second part of the interview. This part is devoted to the control by the Commission of requests for derogation. So the Commission is the guardian of the treaties, and it is competent to review the requests of member states. It has to make sure that the provisions proposed do not constitute arbitrary discrimination, disguised restrictions, or an obstacle to the functioning of the internal market. We already discussed the two first conditions in previous interviews on Article 36. We will consequently focus more on the third condition, so an obstacle to the functioning of the internal market. My first question would be on the interpretation of this obstacle. It is quite vague and new. Can you please tell us how the court should interpret such a provision?
Too strict an interpretation of the condition of the obstacle on the internal market is likely to render the whole procedure nugatory. Bearing that in mind, the European Commission has been taking the view in its different decisions that this third condition is linked to the principle of proportionality. The German toys case is a good case in point in addressing that provision, given that toys do contain a number of metals that are likely to jeopardize the health of the babies and the children. The Toys Directives is laying down a number of thresholds regarding cadmium or lead. With respect to the lead threshold, it appears that EU threshold is insufficient to address the risk faced by children in swallowing paints containing lead, on the account that there is no genuine scientific threshold to limit the exposure. Accordingly, the German authorities have been deciding to adapt for a number of years a very stringent standard regarding to health, departing from the EU Toys Directive standards. The companies, be it Chinese, be it American, be it European companies placing toys on the internal market do comply with the German more stringent threshold rather than the EU less stringent threshold, on the account that the German market is so important within that internal market. It makes sense that the most stringent standards is more suitable to these producers. The Commission took that element into consideration in the assessment of the proportionality of the German thresholds regarding lead. And as a result, the Commission decided that such an approach was proportionate to the objective to protect the health of the children.
Okay, thank you, Professor. Then we will move to other aspects of that provision. Is there any temporal limitation for the Commission to approve or reject a national request?
Yeah, given that the subject is so sensitive, the framers of the treaty have been providing for a time limit of 6 months. That can be extended up to 12 months in as much the matter is complex and is likely to entail a danger for human health. So the Commission is called on either to approve or to reject the application within that time limit. If the Commission does not succeed to adopt such a decision or does not succeed to notify its decision within that time limit, the Member States are implicitly authorized either to maintain, either to adopt new derogatory measures.
Okay, and in case the Commission approves the national request, is there any obligation to modify the directive or the regulation?
Yes, of course. Under paragraph 7 of Article 114, the Commission is obliged immediately to review the standards laid down either in the directive or under the regulation based upon Article 114. This is testament to the dynamic approach buttressing the functioning of the internal markets. Standards need to be reviewed in the light of new scientific evidence, in the light of new technological developments. And so, as a matter of course, the fact of authorizing one member state to apply more stringent standards should oblige the European Commission to reassess whether the directive or the regulation comply with a high level of protection with respect to the environment, the consumers, or the human health.
Okay, and at the end of the day, were member states successful in seeking derogations?
That's a very, very cunning question. Regarding the statistics, it appears that with respect to maintaining measures predating harmonization, member states succeeded to obtain the authorization in half of the cases. Most of these cases related to chemical substances, and the European Commission has been taking the view regularly that the level of harmonization was insufficient, that level of harmonization had to be reviewed in the light of new scientific developments. In contrast, with respect to application regarding the adoption of new measures under paragraph 5 of Article 114, the European Commission has usually been dismissing this application on the account that they are more likely to jeopardize the functioning of the internal market.
Okay, and don't you think that those derogation procedures are running counter the rationale of the internal market?
I will think otherwise, on the account that harmonization is not tantamount to unification. The harmonization is not an end in itself. Harmonization is at the service of the functioning of the internal market. Accordingly, harmonization entails, to some degree, a level of differentiation on the grounds that the European Union is an extremely complex territory, be it with respect to its geography, to its ecology, to the density of population, to the vulnerability of its ecosystems. And as a result, the internal market has to encompass a dynamic approach in allowing, to some extent, member states to maintain or to introduce derogatory measures to the standards that were decided in Brussels by the EU institutions.
Thank you very much, Professor. This is the end of today's interview. So today we discussed Article 114 TFEU and more precisely paragraph 426. So we saw that it is a new and other legal basis to deal with environmental harmonization. We started with a discussion on the scope of this principle, and we focused on the three requirements. So the fact that the measure has to be specific, that it has to be manifest, and that it should manifest itself after the adoption of the harmonization measure, and the fact that it has to be supported by scientific proof. We saw that these three conditions are cumulative and discussed all of them. We gave you some example, for example, the German case organostatics. And finally, we discussed the role of the Commission, the guardian of the treaties that has to monitor the implementation of those measures and to make sure that member states do not adopt measures that constitute discriminatory measures, that are disguised restrictions or obstacle to the functioning of the internal markets. At the end of the interview, we're really focused on this last category because the two others were discussed during a former interview on Article 36. This is the end of today's interview. Thank you very much for watching us.